Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Halloween, Tuesday, October 31st, 2023. We have an old friend with us today and also a new voice for all our listeners talking about a couple hot recent cases from the Federal Courts of Appeals. So we will get to those guests and cases in a moment. First, just a couple announcements. I know some of our listeners go to the annual bash at the Mayflower Hotel in Washington, D.C., the annual Lawyers National Federalist Society Convention. I will be there on the Thursday, November 9th. I'll be there signing copies of my book if you would like to get a signed copy. Right after lunch, you can look me up in the listings. And if you want to tell me a thing or two about what you think of Short Circuit, that is fine as well. I always love to hear from listeners. I'll also be at Georgetown the day before that talking about my book near the end of the day as part of the Georgetown Center for the Constitution's series on new books on the Constitution. So I look forward to seeing some of you at those events. But today I am going in the virtual studio. I'm going to be with our old friend and IJ attorney, Tori Clark. Tori, welcome back to Short Circuit.
Hey, thanks, Anthony. I'm actually, I've transitioned to a new role in IJ. I'm no longer a litigating attorney, but I am doing a potential case intake and coordination for our immunities project and for our Fourth Amendment project. So I'm excited to be transitioning to this new role.
And we are excited that you are taking over that very important work about the cases that come our way in those areas. And we'll be talking about cases actually in those areas today. But also joining us is Katrin Marquez. So Katrin has joined us as an IJ attorney recently, but she is not a stranger to us. She was a summer clerk, a Dave Kennedy Fellow, which we call them now, during law school. She was also a litigation fellow. Is that what we call those folks, Katrin, for us right after law school?
That's what we call them now. When I did it, I was a constitutional law fellow, but that is what we call them now.
Okay, right. Big difference. And now she is working from our Miami office, our Florida office. So tell us a little bit about yourself and what you're working on these days.
Sure. So like you said, I've been around the IJ sphere for a while. I really enjoy it. I graduated law school about 3 years ago, and I couldn't think of anywhere better to work because what can I say? I love fighting for the Constitution, and this is the best place to do it.
Well, I think that's a ringing endorsement. If anyone out there is looking for a new line of work, we always have openings, especially at our headquarters. So check us out on the jobs page. But today we're going to be talking a couple cases about the Constitution. First, we're going to start out west. Tori is going to tell us a tale from the Ninth Circuit where things got a little hot, you might say, for a property owner.
Yes, indeed. Very, very hot in multiple senses of the word. So this case is Moore v. Garnon out of the Ninth Circuit. And I wanted to talk about this case for a couple of reasons. First, much to my family and friends' chagrin, I love to take every chance I can to talk about how un-American qualified immunity is. So thank you for being my outlet for that today.
We are always an outlet for raging against qualified immunity.
Awesome. Well, I'm in the right place then. And second, the underlying case here is a First Amendment retaliation case with a kind of a qualified immunity overlay, which is timely for us at IJ because the Supreme Court just agreed to hear one of our First Amendment retaliation cases, again with a qualified immunity overlay. That case is Gonzalez versus Trevino, and shout out to that team, Anya Bidwell, Willa Ronan, Patrick Giacomo. They're probably working on that briefing as we speak and doing a great job. But this is a really active and interesting area of constitutional law to watch right now. Because, the Supreme Court seems to be taking an interest in it, which is awesome. And as we'll talk about, the stakes are really, really high when the government thinks that it can kind of punish you for exercising your First Amendment rights. So that's kind of my first caveat. My second caveat, I want to say something really briefly before we start about qualified immunity. And regular listeners of Short Circuit might be rolling their eyes because they've probably heard this a lot. But just as a brief refresher, when you want to hold a government official accountable for violating the Constitution, it's not enough to prove that they violated the Constitution, oddly enough. You also have to prove that the violation was clearly established, which courts have interpreted in practice to mean that you have to point to a case with nearly identical facts to succeed most of the time. And not only is this a really high barrier for litigants to overcome, it's nowhere in the Constitution. It's nowhere in our federal civil rights statutes. It's a judge-made doctrine that really gained its legs in the latter half of the 20th century. So it is a high barrier and just kind of a policy judgment that judges have made primarily in the last few decades. So
judicial activism, you might even call it.
You might possibly call it that, yeah. So turning to this case, here in Moore v. Garnon, the Tucson Police Department was investigating a building fire, determined it was arson, and then decided that they wanted to talk to Mr. Moore, who was the person who was responsible for taking care of the building. And so officers went to Mr. Moore's office, where Mr. Moore and his attorney were waiting. And when officers started questioning Mr. Moore, his attorney advised him to remain silent and not answer questions. So on the advice of his attorney, Mr. Moore said, okay, I'm not going to talk to officers anymore. And according to the plaintiffs, at that point, officers became more aggressive. They ended up snatching his phone out of his hand. They arrested him, took him to a police station, fingerprinted him before letting him go. And then a few days later, officers obtained a search warrant for Mr. Moore's home that he shared with his wife. And officers told Mrs. Moore, quote, we wouldn't be here if your husband had just talked to us. And if that wasn't enough, these officers also caused the Tucson PD to open another investigation into financial crimes of Mr. Moore and his wife, which that investigation was eventually closed for lack of evidence of wrongdoing. And so after all of this kind of rigmarole, the Moores filed a federal civil rights lawsuit and also submitted some public records requests relating to what they had been through. After the Moores filed this first federal lawsuit, the officers reopened the arson investigation into Mr. Moore and also tried to induce the IRS to open an investigation into the Moores' finances, I guess because Tucson had not succeeded in pinning them down on anything the first time. So after that reopening, the Moores replaced their previous federal civil rights lawsuit with this one, and they had some Fourth Amendment claims and they had some First Amendment claims, but this opinion specifically deals with the First Amendment claims. And what the Moores argue is that the arrest and the various investigations, among other things, and the search of the home, were all basically officers' attempts to take revenge on the Moores because Mr. Moore first refused to talk to officers, and then the Moores filed their lawsuit and public records request trying to hold officers accountable. So the district court here actually denied qualified immunity, and we can talk a little bit about the jurisdictional piece later if you're interested. The court left open the possibility that it could revisit the qualified immunity issue in the future, but said, right now, I'm denying the motion. But the Court of Appeals, the Ninth Circuit, reversed and held, first, that there's no clearly established First Amendment right to remain silent in police questioning, and second, that there's no clearly established right to be free from retaliatory investigation. So the Moore's first claim was that, again, Mr. Moore's arrest, the search of the house where they said, we wouldn't be here if Mr. Moore had just talked to us, and the various opening and reopening of investigations were retaliation for Mr. Moore's decision not to speak to officers at the advice of his attorney. And so I want to pause here to talk about the First Amendment versus the Fifth Amendment right to remain silent, because that's a pretty confusing piece of this opinion that the court doesn't really get into.
That's the one we all know and love, right? The Fifth Amendment right to remain silent.
Exactly. Most people are probably going to be familiar with the Fifth Amendment right to remain silent. That's encompassed in, like Miranda rights that officers will repeat whenever they're arresting someone. You have the right to retain an attorney. You have the right to remain silent. That's probably the most famous one. But here, the Fifth Amendment, the Moores don't bring a Fifth Amendment claim, and that's probably because the Fifth Amendment has to do with your protections in a criminal proceeding, and how the government can or can't use your decision to remain silent against you kind of in a criminal prosecution. But here, Mr. Moore isn't complaining that they improperly used his invocation of the right to remain silent in the arson prosecution. He's complaining that the officers took kind of additional steps outside of that prosecution to basically take revenge on him for not cooperating with them. And so because of the harm that he's complaining about, that falls under the First Amendment and not the Fifth. I'm using the term right to remain silent because that's what the court uses. But really what this is under the First Amendment is a right to be free from compelled speech by the government. When you think about it, most of the time when you think about a free speech case, right, you think about a situation where the government is trying to suppress speech, keep you from saying something that you want to say. But the right not to speak is just as important as the right to speak in the First Amendment, because they're both central to ensuring the freedom of expression, freedom of conscience, these really rich first principles that the First Amendment was designed to protect. So this is a really important aspect of the First Amendment that is not talked about as much, but still, the right to be free from the government compelling you to speak is really crucial to those protections. Nonetheless, in this case, the Ninth Circuit said, no, there's no clearly established right to remain silent, and specifically, there's no right to remain silent under the First Amendment during police questioning. Now, there is literally a Supreme Court case, Woolley versus Maynard, that says the First Amendment protects your right to remain silent. But the court reasoned that the Supreme Court statement was made at too high a level of generality, which is a really common analysis in qualified immunity cases. And more than that, they say, that was a compelled speech case where in Woolley versus Maynard, the plaintiff was forced to have a license plate that said live free or die, which the plaintiff, didn't want to say those exact words. And so the Supreme Court said the government can't compel that speech. So the Ninth Circuit kind of draws a dichotomy between specific compelled speech and kind of more general compelled speech. But more than that, the Ninth Circuit goes farther and says that in order to overcome qualified immunity here, the plaintiffs would have basically had to produce a case that says there is a specific First Amendment right to remain silent in these exact circumstances, like police questioning. And then the court doesn't even actually answer the question whether there is a First Amendment right to remain silent under police questioning. They just say, well, there isn't one, so plaintiffs leaves, goodbye, which is, again, really common in these qualified immunity cases and very frustrating because it doesn't move the analysis forward for future cases. And briefly, the second claim that the Moores make is that the officers retaliated against them based on the lawsuit and the public records requests by reopening the arson investigation and then trying to get the IRS to investigate the Moores. And here, the court's analysis, in my opinion, is even shakier because the court acknowledges that there is actually a Ninth Circuit case that says retaliatory investigations can violate the First Amendment. And side note, we've actually filed a cert petition at the U.S. Supreme Court on this issue. It's our JTH case, if you want to read more. But here the court essentially says, well, we know that there's this other case, but that case didn't put the officers on notice here because the steps that they took in their investigation are different from the steps that the officers took in the previous case. And the court doesn't say the steps were less intrusive or worse or better for some reason. They don't really explain why that distinction matters. They just say, well, they're different, so officers would not have known that an investigation could have violated the First Amendment. So again, this just goes to show kind of the lengths to which courts will go to dismiss cases on qualified immunity grounds and avoid both holding officers accountable, which is kind of like the immediate harm of these kinds of opinions. But then also kind of long-term, courts also avoid even ruling on important constitutional questions.
Katrin, do you often invoke your right to remain silent? In a First Amendment context, of course.
All the time. Should I do it right now? Probably not the best move.
That's not a hint.
One of the things that I appreciate about this conversation is exactly what Tori said, which is in these qualified immunity cases, it's so common for the courts to just use the level of generality to get out of actually having to decide the issue. Anyone who's really familiar with qualified immunity jurisprudence knows this comes up all of the time. I find this case particularly interesting because Woolley is a case I have read. I know something about compelled speech, but this was in a different context than I've read it before. So I really appreciated Tori's explanation. Something a little bit, actually quite different that I thought was interesting about this case that really wasn't the focus of what Tori said, but I think is relevant is at the beginning, there's a brief discussion about discovery in the case. And I thought that was really interesting because in my own review of qualified immunity cases over time, one of the things that I've noticed is at the district court level, not at the appellate court, sometimes you'll have the courts deny the motion to dismiss based on qualified immunity, but they want to split the baby, so they end up really limiting discovery, and that ends up creating a huge problem later on in the litigation because you get to summary judgment and the court tells you, well, you have no evidence here to support your claim. And it's, of course you don't have evidence. You didn't give me the discovery I needed. And that issue comes up in this case. And I think it's really important to point that out because I think most judges try to do their best, but in doing their best, sometimes they end up creating this whole other problem later on in the litigation.
Yeah, and I think that comes up specifically a lot in cases involving police officers and criminal investigations, because the court is trying to, not impede on a criminal investigation and kind of, be cognizant of the governmental, legitimate governmental interests and not having, all of their investigatory techniques kind of laid out there for the public to see and things like that. But then in the process, they end up limiting discovery more than they need to. And then they come back at a later date and say, oh, well, qualified immunity because you don't have evidence, or, especially in First Amendment retaliation cases, like our Gonzalez versus Trevino case at the Supreme Court, discovery and evidence is really key to proving the underlying claim. Like the amount of evidence that you need to establish a First Amendment retaliation claim in certain contexts is really, really high. And that's something that we're fighting about in Gonzalez. So you're totally right, Katrin, that the discovery piece of it sometimes is a make or break issue.
And we'll be sure to put in the show notes links to the Gonzalez case and what's going on there, which we very briefly previewed on a previous episode, and also the JTH opinion that you mentioned, Tori. Another thing about what happened in the district court in this case that I find concerning is that one of the worst parts, I think, is thinking as someone who is having to, if I were litigating a qualified immunity case from kind of soup to nuts, including in the district court, the most frustrating part of the doctrine from that standpoint is that you can win on qualified immunity if you're a plaintiff, at either motion to dismiss or summary judgment, and then the government official can appeal, even though you're not done with the case yet. You don't go to trial. You don't even go to further discovery. And that's because of the doctrine that the whole point of it is to not waste the government's time with discovery. And so get this on appeal as quick as you can. And here, the qualified immunity was denied, but without prejudice. And I'm not exactly faulting the district court for how it did that, but that meant that appeal could happen at that time, but it could have, like, the government could have filed again later on and lost again and then appealed at that time. So it's really a heads you win, tails you lose in terms of when the plaintiff has to go up to the district or to the appellate court instead of just, winning what can be a very onerous process of either a motion to dismiss or summary judgment, and then being able to get what they actually want to get to, which is the trial where you have a finder of fact find, was this actually retaliation? And instead you can have these multiple appeals even on this initial question.
Yeah, and that is one of the even more formidable aspects of qualified immunity, as if the doctrine itself isn't enough, right? The government can repeatedly appeal this issue, so they get several bites at the apple, and those are interlocutory appeals, which means that they get to put everything in the case on hold and go litigate this. So if you're a plaintiff, especially if you're a plaintiff who is having to compensate your lawyer, and you have limited resources, which many plaintiffs in civil rights lawsuits run into, that's more time on the clock that's ticking away because you're having to wait for an additional appeal. That's additional appeals that you're having to, figure out, or your lawyer is having to figure out, is this worth the money to continue to litigate this? And right, you could lose at any stage of this proceeding. So it really is something. I think I've talked about this on Short Circuit before, but really the interlocutory appeal aspect of qualified immunity is actually one of the most onerous features.
Yeah, it just seems to conflict with a lot of the policy rationale of let's not waste time going through all this arduous process when you just keep going to the appellate court constantly.
Let's not waste time for the government if they seem to be losing. Well, a different outcome, however, occurred out east in the 11th Circuit, where we have kind of a wild but not so wild tale about what it's like to be 17. Now, in years past, 17 maybe meant you could live on your own at that time. People used to get married at 17, start to raise a family. But apparently, according to an officer at this school, being 17 means it's child abuse if you spend a little time in a park. So, Katrin, can you enlighten us?
Sure. So this case is Butler v. Smith. Like you said, it is out of the 11th Circuit. It's out of Georgia specifically. And it, guess what, has to do with qualified immunity, because that's just the theme of the day. So what happened in this case is that there is a family consisting of a single mother of 3 children. We don't know the ages of all of the children, but the important child here is Jaden, who, like you said, is 17 years old. He is a senior in high school, and he is disappointed because his family moved, and because his family moved, he is no longer zoned for the high school that he had gone to for the previous 3 years. At this point, his mom gives him an option. He could continue going to his high school, in which case he won't have any transportation home, or she could transfer him to the school that he's currently zoned in, which would provide bus transportation. He wants to stay at his school, which presents a couple of challenges. So his options become he can hang out at the school until he can be picked up. He can hang out at a local park until he can be picked up, or he could walk home and wait there. Jaden is actually quite friendly with the school resource officer at his school. That's a local cop who is assigned to the school. And he talks to this resource officer, Officer Smith, all the time. They're friendly. She knows him well. They sometimes have lunch together. And one day, one of the things she learns about him is this setup that they have, that after school he could hang out at the school, hang out at the park, or walk home, but he won't have transportation. And she is concerned about this. She thinks it's cruelty to her child. And so she actually calls Butler, who is Jaden's mom, and explains the situation, that she thinks this puts him at risk and that Jaden should not be hanging out after school. First, there's a policy that you can't actually be hanging out on the property of the school. She also thinks he can't get water or food while he's there. He's estimated to spend probably around 4 hours there at the end of the school day before he actually gets picked up to go home. And so they have this conversation, and Jaden's mom explains she is a single parent, so she can't go pick him up because she has to work and doesn't get off to work until later. She does not have her fiance pick him up because there seems to be some conflict between Jaden and the fiance, and she wants to prevent any kind of negative situation. Jaden was given the option of what he wants to do and what school he wants to be at. And there's one other option that Jaden wants to take, which is he wants to go to an apartment complex nearby where some of his friends live, and he wants to hang out with them. But Jaden's mom does not allow that because he has gotten in trouble a few times for doing that. So this school resource officer has this conversation with Jaden's mom. She knows all of this, but she's still concerned. And one day, after school, Jaden goes to the apartment complex that he has been told he cannot go hang out in. And later on, he calls his mom to pick him up, and she says, "You know you're not allowed to be there. I did not allow you to do this. I'm not going to pick you up." So he spends the night with his friends there. The next day, he goes to school again, and he speaks to Officer Smith, tells her what happened. And Officer Smith is quite unhappy about this. Part of the reason Officer Smith is probably unhappy about this is because Jaden actually recorded his phone call with his mom. And in the phone call, Miss Butler refers to Officer Smith in maybe not the most charitable terms. I think at that point she's quite frustrated because she keeps trying to accommodate Jaden's desire to stay in the school, but he keeps creating these problems. And Jaden plays this audio recording for Officer Smith. Officer Smith. She claims she's not upset about it, but there are notes from another officer suggesting she was. And she decides that she has stood by watching this for too long, and she decides to get warrants, arrest warrants against Miss Butler, saying that two warrants, one for first-degree childhood cruelty and one for second-degree child cruelty. First-degree child cruelty has a minimum 5-year sentence for the quote, willfully depriving a child of necessary sustenance to the extent that the child's health or well-being is jeopardized. And then the other warrant is for second-degree child cruelty, which has a 1-year minimum for conduct that, quote, with criminal negligence causes a child under the age of 18 cruel or excessive physical or mental pain. The magistrate judge does issue the warrants, and later that same night, after the warrants have been issued, Officer Smith texts Jaden, and when he doesn't respond within about 10 minutes, she actually has a police unit go check in on him and tells those officers about the warrants. Predictably, this does not go well for Miss Butler. She is arrested and charged with first-degree and second-degree child cruelty, and she has to spend 4 days in jail. 4 months later, these charges are dismissed, but I think we can all agree Butler probably did not have the greatest appreciation for what happened, so she decides to sue for malicious prosecution. And this case ends up before the 11th Circuit, as we said. Malicious prosecution is kind of a difficult claim to bring because there are elements both of common law tort malicious prosecution and Fourth Amendment violations. One thing I appreciate about this opinion from Judge Newsom is that he actually explains what elements you take from each of those so that you understand the analysis, because sometimes these claims can be very hard to understand.
I think it's a very classic Judge Newsom opinion. He tries to really explain everything, which is appreciated.
Yeah, I would recommend it to others. I won't go into the details of all of the elements because there's quite a few. But what's important here is that the 11th Circuit denied Officer Smith qualified immunity, which, for all the reasons that Tori was speaking about earlier, is actually a really big win, because I think it would have been really, really easy for them to say there is no exactly on-point case here and say, therefore, there is no constitutional violation. Because, to be frank, how many cases do you know of where an officer gets mad that she gets called a name and then tries to have a mom arrested for leaving her almost adult child to hang out for 4 hours? Probably not that many. And if you're defining it at that level of generality, she would have lost. But the panel does the right thing. They don't decide to ask that exact question. Instead, they think the right level of generality is to ask whether the type of shortcoming in the warrant application was clearly established. And here they say that it was, because in her warrant application affidavits, she actually omits a lot of important information that would have helped the court understand that Hayden wasn't really experiencing cruelty. So they identify 5 specific omissions that they think are really important. One was that Hayden had chosen to stay at his old school and knew about the issues getting home. He was well aware from the very beginning that he would have to hang out at the school or at the park or have to walk there. And Officer Smith knew about this because she had spoken with Miss Butler and with Hayden. She knew about the different options he had about going home and why some of them were better than others and why he would have preferred to stay close by rather than walk home. Officer Smith also knew about an issue regarding the key to the apartment. So, like I said, one of the options Hayden has was he could walk home to the apartment. He, however, did not have a key to the apartment because he had previously skipped school to hang out in the apartment with friends, and Butler was concerned about this, so she took his key away and said he would have waited for a family member to open the door for him. Officer Smith was aware of this. She omitted it from the affidavits, and that's one of the things the court said, this is relevant information. Another thing that Officer Smith knew was that this apartment complex where Hayden kept going to visit his friends, she was aware that Butler had forbid him from continuing to go there because he kept getting in trouble every time he was there. And she also had made a point in the affidavit that he wasn't getting food for the 4 hours he was there. He didn't have water, he didn't have a snack, and that might be an issue for someone that in the affidavit said had a heart condition. It turns out he didn't actually have a heart condition, but she had a reasonable belief that he did because he had worn a heart monitor at one point. So we're going to let that one slide. There was a reason for it, but she made this accusation that he was being deprived of food, but she also knew that he had been trying to lose weight because he's on the wrestling team and he needed to lose weight for the team. So the court found that these 5 omissions made it so that there was no arguable probable cause in the case, and so they denied qualified immunity, which as with what Tori said earlier, is a big win and one that isn't guaranteed even with when the facts are as kind of ridiculous as they are in this case. So the panel in this case was Judges Jordan, Newsom, and Ed Carnes. Interestingly here, there's actually a concurrence from Judge Carnes where he says that he joins the opinion because the opinion does not say that in when deciding what was important to determining whether there was arguable probable cause, the court didn't say it's okay to exclude inculpatory evidence. So he says, yeah, even if you messed up with the warrant, if you know that there's inculpatory evidence that was omitted, you need to include that too if you include omitted exculpatory evidence in the analysis.
One of the few instances of the word inculpatory, I must say, I don't use very much, which I'm guessing is just the opposite of exculpatory.
I would assume so. I think his point is if they already got a warrant against you with evidence that maybe you didn't do it, but there's other evidence that you did do it, let's include it in there just in case because we want to make sure that we can show you're very guilty. I don't quite understand what his point is there, but he thought it was important to add. Apparently, he's not alone in thinking this. He does say that the Second and Fifth Circuit have said inculpatory evidence should be considered, but it was an interesting aside to the larger discussion, I think.
Yeah, this case is really interesting for so many reasons, and I hope that we get to the parenting aspect of this because I would love to talk about that too and rant about that in addition to qualified immunity. But two things that stood out to me kind of doctrinally looking at this case. The first is that it's kind of a big deal that this case is a malicious prosecution case and that the 11th Circuit, goes into such depths to talk about exactly what is involved in this claim. Because the court cites Thompson v. Clark, which is the Supreme Court opinion from last year, I believe. And in that case, prior to that case, there was a circuit split over whether there even was a constitutional claim for malicious prosecution. But in Thompson versus Clark, the Supreme Court almost kind of like assumes that the claim exists and doesn't really go into a lot of analysis about the circuit split or anything along those lines. There's actually I believe a dissent from Justices Alito, Thomas, and Gorsuch that protest on that exact basis and say, hey, the court's never actually decided that malicious prosecution is something you can bring a constitutional claim for. And so, for instance, the Fifth Circuit at that point didn't think a claim like that existed at all. I think the consensus now after Thompson, even in the Fifth Circuit, is that the claim does exist. But again, I think it's a big deal that the 11th Circuit not only accepts that, yes, this is a claim and does this really thorough analysis of how it works, but then decides that the plaintiff's claim is actionable in this kind of new-ish space. So I thought that was really interesting. The second thing that I thought was interesting that Katrin also talked about is that unlike the Ninth Circuit case we just talked about, the 11th Circuit doesn't actually require identical facts. They say that it's enough to look at this rule that intentionally or recklessly omitting material information from a warrant violates the Fourth Amendment, which kind of from a common sense standpoint makes sense, right? That is a clear rule that the officer could have applied in this particular case and known that what she was doing was wrong. But the court could have easily said, for instance, well, this is a school context and the considerations for security in a school are different from considerations in a regular criminal investigation. So, that means that the previous cases aren't good enough to put the resource officer on notice. But they don't do that. And they look at, like I said, kind of a common sense reading of the case law and say, yep, that's enough to clearly establish this right, which I think is great.
Yeah, I think one thing in the background is just the common sense parenting and that's how Judge Newsom opens it. Parenting is hard. Raising children requires patience, sacrifice, and tenderness. It also requires tough choices, and sometimes it requires tough love. And kind of what's in the background here, I think, is this is a very reasonable way to treat a troubled 17-year-old, especially in the mother's circumstances. And it's kind of too bad, I think, that the case, I mean, it's because of how these types of cases work. The actual legal analysis revolves around what was given to the magistrate judge and what was in the warrant and whether the warrant, there was probable cause or not. Whereas, even just the choice to go before the magistrate judge, I think if we had our druthers right, it wouldn't turn on whether there's arguable probable cause about what's presented to the magistrate judge. You should look at the whole universe of what's going on here and say that this is a completely reasonable way for a 17-year-old. We're not talking about a 9-year-old here. We're talking about a 17-year-old who has made his own choices. I mean, I think even if this 17-year-old didn't have a choice as what the school to go to, this is not child abuse. This is not anything close to a year minimum in prison or 5 years minimum in prison. One thing that's not talked about is, like, is this kid's life going to be better off if his mom is put in jail for a year or put in jail for 5 years, where he's going to be 18 and emancipated soon anyway, where like all this would be beside the point. That they could have made hay about that, but instead, I get it. They go this kind of more narrow road. This was all just completely ludicrous what this woman did. And they luckily they found a way to get there, but kind of in the background is just, this is not the way that parents should. This is not a standard that parents can be held to.
I agree, and I think the judges recognize that. It's not as evident from the opinion itself, but if you listen to the oral argument, there's a lot of discussion of, this is a 17-year-old. He is hanging out at school. How is hanging out outside of the school and maybe at a nearby park an ideal situation? And it's interesting because the attorney for Officer Smith starts talking about, well, it's a dangerous area. You don't know what's happening. And at one point, Judge Jordan, I guess he's a little bit perplexed. He's like, I don't understand how anyone would see these charges applying to this situation. And he actually has a quote that I wrote down because I thought it was excellent, where he says, a law like this is quote, not meant to target a parent doing the best they can, but can't do the best that society hopes for. And I thought that was such an excellent point, because he's saying, yes, it's not ideal that the child has to spend for actually maybe fewer hours. There was some factual debate over that as well. Hanging out, it's not ideal, but that's not child abuse. And the idea that you're bringing this charge is utter insanity.
Yeah, and the Supreme Court, in a different context, but the Supreme Court has recognized kind of the constitutional magnitude of the importance of making parenting decisions for over a century now. I mean, this is a really well-established part of constitutional law, and what the Constitution protects is a parent's right to make a decision that someone else might disagree with about how to parent their child. And, for me, I'm sort of a parent. My first one is on the way and will be here fairly soon. But anyone who, has experienced, expecting a child or having a child, I think has had similar experiences where everyone has an opinion about what you should or shouldn't do. The random lady that you end up next to in the supermarket thinks that you shouldn't have this sleeping arrangement or that feeding decision or anything like that. And it's just a pervasive part of society. And that was really what I was thinking about as I was reading this opinion, is just, maybe it's not a perfect solution, but this is so within this mom's rights to make a parenting decision. And we have to give people latitude, and the Constitution gives people latitude to make these kinds of parenting decisions for their own children.
Yeah, and yet that's a good point. Sorry, one thing that doesn't come up at all, because it doesn't really need to, but could have thrown in there, is what, of course, we talk about in our school choice work, which is the fundamental right of parents to make decisions for their upbringing of their children, which is this decision was completely within that fundamental right. One other thing that the court does address, but I think it's just kind of Looney Tunes that it's in there also, is that she was held for 4 days in jail, and you're supposed to have 48 hours minimum, but unless there's some special circumstances. Justice Scalia thought it would be 24 hours minimum when that case came out a number of years ago. And yet somehow it's like, I think from what I know about state courts in Georgia, this is kind of par for the course. In fact, it's kind of, there's a lot of worse stories out there, as our friend Andrew Fleischman has told us in the past. But 4 days in prison, and it's not even like a big part of the opinion.
4 days in prison for giving your child the option of staying in the school that they know and love. That is insane.
This is a story I may have told on Short Circuit before, so I apologize for any longtime listeners. But whenever I think like, is this okay for your child to do? I think of the story that my wife's now departed but beloved grandfather told me, that he grew up in the Depression. They lived on a farm in rural Wisconsin, and his mother, this is what he told me, his mother would give him and his little brother, who was 2 years younger than him, and he was 5.5, and his little brother was 3.5. They would give them this huge carton of eggs and a bag with like a grocery list, and they would walk a mile to a little grocery store. They would hand the carton of eggs to the grocery person, and that was like their payment for groceries. The Depression, right? Not a lot of money, but they had eggs. So they gave the eggs. The woman would open the bag, get a list, fill up like a bag with the groceries, and then give it to them, and they would carry the groceries back home a mile each way. I don't think that was child abuse. I think that was perfectly fine. I think it would be fine for people to do today, although I wouldn't recommend it because resource officers probably pick them up pretty fast. And if that's not child abuse, then Jaden waited in the park certainly is not child abuse. So anyone out there wondering what kids should be doing, this is okay, and please mind your own business. So thank you, Tori and Katrin, for not minding your own business and joining us today on Short Circuit. Hope everyone enjoyed those stories. We will have another episode next week. Again, look for me coming if you're going to be in at the Federal Society Convention on November 9th. But in the meantime, I'd ask that everyone get engaged.